Okay, we are on chapter 15, excuse me for this interruption, dealing with creditor-debtor relationships and bankruptcy. So, first thing we're going to talk about is liens. Okay, a lien is an encumbrance on, that is, it's a claim against property. It can be real or personal property, and it's a lien that's there to satisfy a debt that the person who owns the property owes to another person, or to protect a claim for the payment of a debt. Liens can arise under the common law or under statutory law. A common type of lien is a mechanic's lien. Don't be misled by the word mechanic because it has nothing to do with mechanics. It actually has to do with real property. When somebody does work on your real property, the worker gets a mechanic's lien for any amount that's due that goes unpaid. They can perfect that lien by filing it with a courthouse, and that protects them. So how does it protect them? Well, the lien goes with the title to the property. So if you go to sell your property and there's a lien on it, chances are the person who's buying the property or interested in buying the property is not going to buy it because of the lien. So most of the time liens are paid off before that time. And so that protects the person who holds the lien, and they'll eventually get paid. Of course, that's a rare situation because most people don't want liens on their property, and they will pay their debts. Okay, if the lien is foreclosed on, which the lien holder can do, then the property is sold and the proceeds pay the debt. The remainder goes to the owner of the property. That's a fairly rare circumstance, although the larger the debt, the more likely it is that something like that's going to accrue. Another type of lien is called an artisan's lien, and this is on personal property. It operates similar to a mechanic's lien. It's for services performed to repair, improve, or enhance the value of personal property. In this situation, the person doing the work on the personal property that gets the lien has to hold on to the property. That is maintained possession. And the lien is terminated once the money is paid, or if the property is voluntarily surrendered, unless this surrender is temporary. So modern statutes allow the holder of these artisans' lien to foreclose and sell the property, and then it goes just like it does with a mechanic's lien. The proceeds go first to the person holding the lien, and then the remainder goes to the owner of the property. Judicial liens are created by a creditor bringing a legal action against the debtor to collect the past due debt. If this is so, then the court awards a judgment. In other words, you have a civil suit suing an alleged debtor. The court rules in favor of the creditor, the plaintiff, and issues a judgment. So then the question is, how do you collect on that judgment? And there's several ways to do so. First of all, you hope that the debtor, if you're the creditor, you hope that the debtor's just simply going to pay you, write you a check, or hand you cash. If that's not the case, then there are other things that you can do. One is called filing with the court for a writ of execution, okay, or a writ of attachment. A writ of attachment occurs before a judgment in unusual circumstances where there's a possibility that the property might be dissipated in some way. Because that's so rare, we're not going to really talk much more about it. A writ of execution is the main one that we would want to talk about. And that's an order from the court based upon the underlying judgment that orders the sheriff to go out and seize the property of the debtor and sell it at a sale and apply the proceeds first to the creditor and then any remainder to the debtor. This is a very extreme thing to do, but sometimes necessary in order to collect on a debt. Okay, the Due Process Clause requires that the debtor be given notice and an opportunity to be heard, and of course you have to have a right under the law to seek that payment. Okay, we're going to skip that. Now, note this. This is kind of important in Georgia. In Georgia, we don't call it a writ of execution. We call it a FIFA, which is right up here. So if you hear a lawyer say you need to get a FIFA, it means that you need to get a writ of execution. You need to get an order from the court to allow the sheriff to take the property of the debtor and sell it. And of course, it applies only to property that's within the jurisdiction of that particular court. Again, the proceeds are used to pay the judgment, accrued interest, and cost of the sale, and any excess goes to the debtor. Generally, the law allows the debtor to redeem the property while it's in the hands of the sheriff and before it's sold by paying all these, by paying the debt and the expenses, etc. Okay, another method of collecting on a judgment is by garnishment. Everybody's heard of garnishment. Garnishment is an unusual procedure because it's actually another lawsuit after you have a judgment from the court. You file your lawsuit called the garnishment in the court, but you don't file it against the debtor. You file it against a third party who's holding money that belongs, or assets that belong to the debtor. The debtor has to be given notice of this. The third party then, the garnishee, has to file a response with the court saying to the court what property, if any, they're holding of the debtor, and then turn over that property up to a statutory amount to the court, who then turns it over to the creditor. If the debtor believes that there's no debt owed or that something's being done wrong, they can challenge the garnishment by filing what's called a traverse. In Georgia, we have two types of garnishment. One is just a garnishment where you garnish the third party once. The other is called a continuing garnishment. So you don't have to keep filing lawsuit after lawsuit after lawsuit until the entire debt's paid. You file a continuing garnishment, and the third party has to periodically report to the court what they have and turn it over to the court. So it can be a prejudgment remedy just like attachment can be, but that's extremely rare. State law, of course, governs garnishments except for the amount that can be garnished. That is actually covered by federal law. So federal law protects people from having too much money garnished so that they can still live a life. And so this is the formula that's used to do that. Notice that there's two, A and B, and it's the lesser of these that applies. So you have to figure out both formulas, then you take the result from both formulas and take the lesser of those. So the first one is 25% of one's disposable earnings. So let's make it simple. Let's say you earn $125 for the week that the third party's holding your check, but after taxes you only have $100 left. They can garnish 25%, which would be $25. The other formula is the total amount by which one's weekly wage exceeds 30 times the federal hourly minimum wage. So you take the hourly federal minimum wage, you multiply it by 30, then that amount is subtracted from then you can only garnish what is over that amount, that sum of the 30 times the minimum wage. Okay, so it's the lesser of those two. So obviously, the second is only going to apply in situations where the person earns a very small amount of wages. The employer cannot fire the employee for having their wages garnished, but it's a one-time limitation. I don't think your book says that. I think it says something else, but that's incorrect. I researched that. Okay. Another way of resolving a debt is a creditor's composition agreement, which is basically where the debtor and creditor sit down together and work out some payment arrangement. They're usually considered enforceable unless they're done under duress. Okay. So, I'm going to stop here and we'll pick up here with part 2.